Hello, my name is Adam Goodman, and I practice criminal law in Toronto. This video is meant to provide a very basic overview of the bail hearing process. The bail hearing is a very important stage of the entire criminal court process, as it will determine if an individual is held in custody pending the outcome of their matter, which can be months or even years away, or if they can be released in the community. While many individuals are released from the police station, there are many that are held for a bail hearing. The vast majority of bail hearings will occur in the Ontario Court of Justice before a judge or a justice of the peace. It is at this hearing that a judge or a justice of the peace will determine if an individual should be released into the community. The vast majority of bail hearings will occur in the Ontario Court of Justice. Bail courts sit every day of the year, including weekends and statutory holidays, as arrested individuals have the right to appear before the court within 24 hours. In certain cases, the Crown Attorney will consent to the release of an arrested individual. In these cases, the lawyer will be able to work with the Crown Attorney to negotiate release conditions. For individuals who are facing other charges, the Crown Attorney might bring an application called the Section 524 application for the cancellation of all of their outstanding releases. In such cases, the Crown Attorney may request a 3-day adjournment in order to bring the proper paperwork before the court. When considering whether an arrested individual should be released, the court is going to consider 3 grounds. The first ground is called the primary ground. This involves whether the individual is going to come to court for all of their court appearances. The second ground is called the secondary ground. This involves whether there is a substantial likelihood that the arrested individual will commit further offenses while out on bail. The third ground is called the tertiary ground. This involves whether it would be against the public's interest for the individual to be released on bail pending their trial. The best way to address all 3 grounds is for an individual to present a plan for their release into the community. A plan of release will generally involve the use of sureties. A surety is an individual who will pledge a certain amount of money to the court to ensure the court that this individual who has been arrested will make all of their court appearances, as well as follow the rules that have been imposed by the court. In most cases, a surety does not have to provide actual cash to the court, but will rather pledge an amount of money that they can lose should the individual not follow the conditions of their release, or should they commit further criminal offenses while out on bail. The basic role of the surety is that of a jailer in the community. They need to ensure that the arrested individual follows any of the conditions that have been imposed by the court. Examples of conditions may include a curfew, a boundary condition, or a requirement not to communicate with the alleged complainant. Once a plan of release has been presented, a court will determine whether or not the individual should be released into custody, as well as what conditions will be appropriate for their release. An experienced criminal lawyer will be able to make representations to the court that explain why an individual should be released. They will also know the law of bail and will be able to make legal arguments explaining why a release is most appropriate in given circumstances. For more information on me, Adam Goodman, and my practice, as well as information about the law of bail, please visit my website at www.aglaw.ca, or feel free to call me at 416-477-6793. Thank you very much.